All right, I'd like to call this August meeting of the Hudson River Black River Regulating District to order. Could all stand for the Pledge of the Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Reminder, if you could please turn off any pagers or cell phones, or at least put them on silent or vibrate. Thank you. Roll call.
David Bergstrasser.
Here.
Michael Asselkin.
Here.
Albert Hayes. Here. Philip Klein.
Here.
Thomas Stover.
Here.
Mark Finkel.
Here.
Michael Clark.
Here.
Robert Leslie.
Here.
Robert Bolton.
Here.
Carol Wright. Richard Ferrara. Here. Mr. Chairman.
Thank you. Thank you. Thanks for coming. I need a motion to adopt or revise the meeting agenda.
So moved.
I have
Second.
a motion and second. All in favor?
Aye.
Opposed? List of guests. Do we have any guests, speakers? Mr. Mayor, would you like to speak?
Sure.
Thank you.
Anywhere?
Yeah.
First of all, good morning, Mr. Chairman, members of the board and staff. I want to give you a hearty welcome here to City Hall. We're glad you chose our location here. It makes it more convenient for me to speak here at this particular topic as well. The City of Watertown is the owner and operator of a hydroelectric plant on Marble Street, and it's an important part of our revenue streams and so on. And so we feel a little bit of a vested interest in our working relationship with this particular board. I think we pay $28,000 roughly a year in fees, and it's not a big thing in the total picture, but we feel we're stakeholders in it. So when I heard that a rather large sum of money from the Black River collection basin was going to be diverted to satisfy a debt in southern part of the state, I sympathize with our friends in the Hudson Valley. I really think it's important that the revenues from this area stay in this area to help service what we do up here. I don't know whether this decision has an effect on future rates or levies against us. I'm not that intimate with the nuances of the process, but I would urge the board to reject this resolution and retain the dollars in the northern area. And I thank you very much for your time.
Thank you. First speaker I have here is it Jeff Graham? I'm sorry. Oh, I'm sorry. Jeez. Mr. Blankenbush?
I'm Ken
Assemblyman?
Blankenbush. I'm the Assemblyman who represents the 122nd District. And I'm here today to talk to you about why I don't believe that spending, borrowing that money, giving that money to the Hudson side is viable. And I have a couple of concerns and questions. I understand this isn't a lot of question and answer period, but there's a few things I'm concerned about. And one of the things is that on the Hudson side, the hundreds of thousands of dollars that's being wasted by the regulated district board on administration, lawyers, expensive office space. I look at it and I say it's no wonder that the Hudson River side is broke. Taking the assets of the Black River area to shore up the broke Hudson River side is not only a bad policy, but it's also against the law. The state dictates that the Hudson and Black River budgets must remain separate, and the state controller has upheld that in 2009. A vote by the Hudson Black River Regulating District Board to commingle the funds will not only negatively affect the Black River region, but also stands financially drown the entire entity. Although the Hudson River side is broke, I have questions on a lot of things that expenditures that happened over this last year. Hiring a new full-time executive director for $97,500 a year after having no executive director during a the prior year. Total expenses, when you add up benefits, is over $125,000. Appointing and acting Hudson River area administrator at $68,000. Duplicating office space, not only in your Albany office, but your field office. Over 5,000 square feet in that field office with only 4 employees. The administrative staff in Albany, that includes full-time counsel at $92,500, full-time chief financial officer at $87,500, administrative assistant at $64,000, and the executive director at $97,500. No administrative cuts were made when the 12 employees were laid off in that field office. In addition to that, my understanding is, and again, if I'm wrong, I'm not going to ask questions, but my understanding is this. Why did you approve $30,000 in new administrative salaries for the same people doing the same job in the past year? Again, under the financial problems that we're having. Why were these promotions approved when the majority of the operating personnel were laid off as work was drastically reduced? Why do we have a full-time attorney? You're represented by the Attorney General. And in past, there was a part-time general counsel, which exactly would be saving the district money. Why do you have an Albany office? At the same time, you have a field office. Duplication of offices and expenses, in my opinion. If the loan from the Black River side to the Hudson side, if it was called a loan, reading the resolution, I see nothing in that resolution that gives a payback schedule or talk about a loan and monies going from the Hudson side back to the Black River Valley, the Black River side. That indicates to me that there's probably not ever any idea of paying that money back to the Black River side of the district. You take $3 million from around $3 million from the Black River side to the Hudson side to pay for a $4.9 million tax. You got $1.9 million still out there. How are you going to pay for that? $3 million over from our side, the Black River side to the Hudson side, still leaves you with $1.9 million. I see nowhere in how we're going to pay the balance of that $1.9 million. The other thing I have a question on is, that's old taxes. Pretty soon you're going to have another tax. You're going to have taxes coming back this year, 2011, 2012 taxes. How are you going to pay for that? $3 million is not even going to take care of the old taxes, let alone now the new taxes coming into that the Hudson side will own. It's evident to me that these examples of unnecessarily and wasteful spending, the Hudson side, the board, and the administration are more vested in themselves than serving the residents and the communities in these areas. This attempt to force the Black River region to lend the Hudson River money to pay its debts is nothing more than an attempt by the eastern region of our state to bully the North Country. As one of the state legislators representing the Black River region, I join my colleagues in supporting the split of the regulating district into two separate entities with two separate boards. And I want to thank you for your time.
Thank you very much for your input, Mr. Zabu. That's the last name I have on my list of speakers. Is there anyone else that would like to speak that hadn't signed up? Okay, thank you. Do we need a motion for executive session? Anyone? Any reason?
No.
Okay. Now, public comment period. We just did. Yeah. Where did it come from? All right, I need approval of the regular board minutes from July 12th, 2011. And any questions or discussions on it?
So moved.
All right, I have a motion. Do I have a second?
Second.
I have a second. Motion and second. Any further discussion? All in favor?
Aye.
I'll abstain.
Okay. Opposed? So moved. Could I have the report of the executive director, please?
Thank you, Mr. Chairman. Since the July meeting, the vast majority of director's time has been occupied and fully involved with various matters of litigation, including the 5 county assessments litigation, and the Fulton County issue, the tax litigation also, and the current status of that, which brings us here today. Also, as a separate matter, I did this past weekend give a presentation to the Great Saginaw Lake Association over the weekend, and its members and guests. Be happy to answer any and all questions.
Anyone have any questions for Mr. Park? Let's get into committees. Governance Committee.
Thank you, Mr. Chairman. I'll remind everyone that we're in committee right now. There's no old business, unless you gentlemen know of any that should have been on the agenda. I hear none. Okay. New business. If the committee so pleases, there's really nothing in the next 3 items that would warrant our discussion as a committee. Then I would look for a motion to bring it to the full board. No motion? Okay.
Okay, I'll second it.
Second the motion. All right. Any discussion on the motion? All in favor?
Aye.
Thank you. Okay.
All right.
I'll just, Mr. Chairman, you want to handle it? Okay,
You
go
want to
ahead.
bring it to full board? or-
Yeah, there's
Yeah.
no sense committee.
No.
Okay,
Okay.
go ahead.
All right. First thing we have is a resolution to solicit legal services for Albany Engineering versus the Hudson River Board. I will ask, how about Mr. Leslie to explain the nuts and bolts of it?
The Albany Engineering, formerly known as Fourth Branch Associates, brought a suit against us this past week, demanding refunds of monies paid. For whatever reason, I don't have my copy of this in front of me, but try and do it from memory. That's not it.
Last page.
Okay, last page of that. All stapled together. Okay. Albany Engineering basically brought a suit against the regulating district, filed through a summons complaint filed on me in the Albany office on the 4th. On the 5th, we requested the Department of Law represent us in that case. They have had some preliminary discussions, but have not yet indicated whether they ultimately plan to do so. An answer will be due shortly in this matter, and were the Attorney General to elect not to represent the district, we could be in the position that we've been in before, where we have a need to interpose an answer on a case of some note, represented by learned counsel, outside counsel for them, and therefore we would be best served by having outside counsel represent us. Typically what the Attorney General does is if they do not represent us directly, they've asked us to get outside counsel to represent us in these cases. What we're doing today with this resolution before you is basically giving staff authorization to go out and solicit through our normal procurement process, or a truncated procurement process, for legal counsel, with the expectation that at the September meeting, if we can pull it off, or the October meeting if we can't, we would be coming back to you with a proposal to hire some counsel after they've been vetted through the procurement process. So basically, that's all this resolution does.
You will continue to converse with the AG?
Yes. We've had some positive conversations with the AG, and we're hopeful. And yet, this backstop measure provides us with the opportunity to tell opposing counsel that we need a little bit of extra time, as opposed to we don't know how much extra time because we haven't even brought it to the board yet.
You said we had to do it shortly?
Typically, it's 20 days. We will, in all likelihood, be asking for an extension of that time period, whether the Attorney General represents us or not.
Okay. All right. Any other questions? All right. So we have a proposal, a resolution to solicit outside counsel if necessary. Do I have a motion? So I have a motion. Do I have a second?
Second the motion.
All right, thank you. I have a motion and second. All in favor?
Aye.
Any opposed? Okay. Thank you. All right, the second one I will defer to Mr. Leslie again, a resolution to amend the legal service contract.
Mr. Farrar assures me this one is right on the first page of the packet he's provided me. Every year since 2000, Niagara Mohawk Power Corporation has filed 3 things with us. One was an administrative case in which they demand a hearing on an apportionment. 2 is a notice of intention to file a claim in the Court of Claims. And 3 are a pair of Article 78 actions claiming that the assessments on the Hudson River side and the assessments on the Black River side to Niagara Mohawk properties are ultra vires, beyond law, unconstitutional, wrong before mother and God, and all sorts of other claims. Up until the reapportionment in March of 2010, NIMO filed that second suit in both Hamilton and Herkimer counties. Since then, they have filed that suit only in Herkimer County, basically bringing that assessment case forward on the Black River side. We have been ably represented by an outside firm. It started off as Crane, Parente, and Turbin. Mr. Turbin ultimately moved to his present firm 18 months ago or so, I think. The board at that point approved a modification of the contract to Brown and Weinraub, which is Mr. Turbin's present firm. And this resolution would basically amend that contract with Brown and Weinraub to alter the meaning of the word litigation in that contract to incorporate this 2011-2012 challenge to the Black River area assessment. So all of that comes down to, we have a current firm, they are representing us in a series of lawsuits, and this is the next in that series of lawsuits. In order to be open, notorious, and above board, we're bringing a resolution before the board to authorize the inclusion of that additional lawsuit into the mix. Here again, we've had discussions with the Attorney General, who has not yet given us an answer. This also happened last week, so I'm not surprised that they weren't able to give us a quick decision, or a lightning-fast decision. I'd be happy with a quick decision. They may pick up this case. If they do, then this resolution won't be necessary.
So we're just adding this one to the list.
We're just adding this lawsuit to the list of lawsuits that they already represent us on.
All right. Any other questions from Mr. Leslie? Or Mr. Brewer?
Contract as stated.
Do I have a motion? Do I have a second?
Second.
Okay, I have a motion and a second. Any further discussion? All in favor?
Aye.
Opposed? So moved. Mr. Leslie, your counselor's report?
Yes. My month has been, like Mr. Clark's, consumed by litigation. We were sued a couple times this week, as we just discussed. We are involved in the 5-county suit. That is the source of our difficulties in meeting our expenses. It's not so much an expense problem as a revenue problem. If the 5 counties were to pay their assessment, we would have money to pay all of our bills, including not only back taxes, but taxes going forward. The Attorney General's office, we have been speaking with them with appeals and opinions and with their civil recoveries unit. Appeals and Opinions is handling the appeal by the 5 counties of the Saratoga County Supreme Court, which approved of our handling of the March 2010 apportionment. The 5 counties appealed it, and the Appeals and Opinions Bureau of the Attorney General is defending that appeal. We believe our likelihood of success there is pretty strong. The Civil Recoveries Unit is bringing an affirmative case to reduce the Saratoga County Supreme Court judge's judgment to a money judgment, so that ultimately, when the appeal is resolved on the 5-county suit, we will have a money judgment that we can immediately compel those 5 counties to each individually make their payment on the assessment. So we've been working on that. That's a new development in that case. As you know, the reason for the meeting here today, the Fulton County Supreme Court issued a decision which compels the regulating district to pay the entire $3,045,337.65 that we owe to Fulton County, and through them to the 3 school districts that had sued us over non-payment of those taxes. In your packet today, you're going to find the resolution through which the board would authorize that liquidation of Black River funds. I've been working on putting that together. There is no update yet on the federal court permit system and assessment challenge. We did file our reply brief in the NMA, and that reply brief awaits the U.S. Court of Appeals Second Circuit decision. No. Yes. The McDonald's had brought a suit against the regulating district and their adjacent permit holder, Judith Campbell. As you know, the Albany County Supreme Court, Justice Devine, dismissed that case. Mr. Churban had represented the regulating district in that case, and during the appeal, to the Appellate Division 3rd Department. He argued the case, and on July 21st, the Appellate Division dismissed the McDonald's appeal. So that case, barring a Hail Mary to the Court of Appeals, should be over. We have filed our motion to dismiss in the Christine Chera matter. We are waiting for the court's decision in that matter. In this group of annual Niagara Mohawk assessment cases that we just talked about, the Sacandaga Protection Committee has also filed a motion to intervene, and the return date for that motion is August 25th. So we'll be able to tell you by the September meeting, I suspect, whether the judge has allowed the Protection Committee to intervene in that suit. If they do so, I expect that they will be on our side, and therefore we don't anticipate offering up any opposition. That is, in brief, the litigation that has taken place since I have last had an opportunity to talk to you. In all deference to the Assemblyman, I was pretty busy. Any questions? I'm certainly available to answer them.
Anyone like to entertain any questions? Mr. Leslie? Thank you. Finance Committee.
Mr. Chairman,
Stone.
we have no expenses this month to approve, and with no old business. And under new business, we have the Chief Financial Officer's report. Mr. Ferrara, please.
Thank you, Mr. Chairman. I also have an abbreviated report for the board. The current Hudson River area fiscal situation remains relatively unchanged. We continue to run at the same structural deficit that we have been running at for the last 18 months or so. Estimated depletion of cash flows in the Hudson River is still estimated to be somewhere around the end of the last fiscal this last fiscal year of ending June 30th, 2012. There are several one-time significant expenses in that analysis which may be further deferred, but we're not there yet, and we're working on things that might make that happen. The independent auditors, as I mentioned to the board last meeting, have begun their field audit in Albany. They actually started yesterday. They'll be in all week, and I'm told they'll be completed by Thursday, and a preliminary findings of that report will be provided to the board at the September meeting. I fully expect the audit firm to have the completed audit of June 30th, 2011 completed at that time, so as to meet the public authority's requirement to have that posted on the authority's report website by June 30th, 2011.
September 30th?
Say again?
Sorry. September 30th?
Did I say September?
No.
September 30th. What did I say?
He said June 30th. I think he meant September.
September 30th is the report. Thank you. I also received the estimated retirement bill for this upcoming year, 2011 and 12. This is a bill of particular interest to myself and should be for the board. It does reflect the adjustment for the reduced labor following the layoffs of May of 2010. That's the good news. On the bad news side, it also includes the cost of the retirement incentive that was taken by 6 employees, I believe. I am analyzing that bill, and I will report to the board in September as to my findings as to its accuracy. Finally, there was something last minute that came up yesterday, and I did provide the board with a memo concerning a gate job at Stillwater. There was, it was determined that there is a need to replace a bent stem at Gate 3 in Stillwater. The next page, you see an expenditure request to use basically Rodney Hunt, because this is kind of a single source deal, proprietary spec. This did go out to bid previously for a gate job, and only Rodney Hunt demonstrated the ability to do it due to that proprietary spec and approach. It is for $10,565. Normally, this would not require board approval, even though it is over $5,000, if it is specifically in the current budget. In this case, it was only $4,000 budgeted, so this does require the board to, by motion, and I'm suggesting the board just make a motion to authorize Carol Wright, the Black River Area Administrator, to go ahead and proceed with this work, with this procurement. And then also, upon review of the Gate 3 analysis, I was looking at the capital project schedule and did note that a previous Gate 5 job, which is basically a very similar job, as I understand it, was procured and completed last fall. That job was for $8,890. As I was reviewing the budget for this Gate 3 job, I discovered that the Gate 5 job was not, in fact, budgeted. So that $8,890 was not approved by the board. The oversight was mine. There was a single line item, actually two, for a gate seal job for $16,000, which was the line item I assumed was to cover this job. Upon further discussion of the Gate 3 job with the chief engineer, that surfaced. So I wanted to make that known to the board, and that is just informational. The job is done. I think upon, if we would have procured it, it would have been procured the same way. So in this case, it only did not receive the board's approval. So I'm bringing that to the board's attention. But for purposes of the Gate 3 job, I'm asking the board to make a motion to authorize Carol Wright to proceed with this procurement.
I'll move that as a motion.
I'll second.
All right, motion and second. Any more discussion? Are we still in committee? Oh, I'm sorry. Yeah. Sorry.
Two people.
All right.
Vote? Did you vote?
Well, hold on. We're in committee. It's in committee, so.
Oh.
Tom?
Oh. Okay, well,
Mr. Stover.
You probably, this is probably best to the, because it really is, it's not a finance
Okay.
item. I would probably suggest we put it out to the full board. I would just suggest, I mean, we can do it in committee.
That's no problem. All right, bring it up to full board. All right, so I have a motion and a second. All those in favor?
aye.
Aye. Any opposed? There's a major discrepancy in that Gate 5 between the three prices. Is it because he owns the drawings? Oh, okay,
They already have the drawings.
right. That's what I thought. Thank you. Okay. Anything else? Thank you. We're doing that short notice. Operations Committee, Mr. Hayes.
Thank you, Mr. Chairman. Under old business, we have no old business. Under new business, we have the chief engineer's report here, Mr. Fulton.
Thank you. Just give a brief overview. It has been dry, as you know, in both areas, but despite that, Stillwater Reservoir, we're just slightly above, 3/4 of a foot above our target, and tracking that target curve pretty well. Old Forge and Sixth Lake, we're right on target, as historically we are for this time of year. And in the Hudson River area, at Indian Lake, we are also on target, despite the lack of precipitation. And at Great Sacandaga Lake, as we have found typically when we have a drier period of time, our need to make releases to supplement the flow in the Hudson has brought the reservoir about a foot below the target elevation. Although we are approximately paralleling that curve, we're a little bit low there relative to that target elevation. But I don't see in either the Great Sacandaga Lake or Stillwater case being off that target any concern at all. It's typical for this time of year. So, if there are any questions, I'd be glad to take them. Otherwise, that will conclude it.
Just the one my daughter asks me all the time about water release for her rafting trips.
Sorry, it's only 16 CFS right now out of Old Forge.
I tell her good luck. Thank you.
Thank you, Rob.
You're welcome.
The Hudson River Area Administrator, he's being excused today, not unless Mike might have something.
I will, Mr. Hayes, if you don't mind, I'll give a very brief summary on behalf of Mr. Hudson, the Administrator. At the Sacandaga Field Office within the Hudson River area, there was confined space training. Actually, it was specific to the new hoist that we use at the Conklerville Dam to extract an injured worker from the valve gallery, which is confined space, and it's more than 60 feet within the depths of the dam. So that safety training was conducted. The traffic in and out of the Sacandaga Field Office, according to Mr. Hodgson, has been brisk. People are at the lakes this summer, and permit holders are bringing a lot of questions in and out of the office, and also were permit applications as well as new access permit applications. Field surveys are progressing, and of course our small crew still continues to survey, stakeout, and work permit inspections every day. Thank you. That's the summary that I have for the Administrator.
I will too keep my report short and sweet. Obviously, from the previous motion that you have approved, thank you very much. We have spent the last month decommissioning Gate 3 and inspecting the well and the stem, and found that we do need to replace the stem, and we will be adding additional brackets in the well on the wall of the well. So that really has taken up a very good part of our last month plus. The field staff also has been busy with designing and fabricating a structure that we're going to use on the face of the dam. We're doing repair work to the surface of the Stillwater Dam as a result of our FERC inspections request last year, and we're still working on it. But we found working on it last year that maybe we need something a little bit more mobile, I guess, for lack of better words, to use. And so the guys have come up with a great structure there and safe. In other times, we are doing our normal maintenance and operation, mowing and taking care of the dams and the gatehouses. We are in the process of doing some painting on the structures at the RFO so that we can maintain the structures there. In our office in Watertown, the staff is still working on our maps and our design drawings, and as far as getting them organized and in some kind of good order that we can, and familiarization, I think is a fair term. We now are doing digitalizing our board minutes for the last year so that we can do some saving of space also within the office. The only other thing is I did meet with a code enforcement officer in the town of Webb to discuss our proposed projects of putting in a new septic system in Stillwater, and also for the proposed garage that we have budgeted for. That was...
How did that go?
It went well, actually, very well, thank you.
Any other questions for Mrs. Wright? All right. Let's get on to board business. Old business. None. Under new business, I would like to go on record to state that the reason why we had to hold this meeting today is that we were denied a request for an extension so that we could hold this, discuss this business at our regular September meeting by Fulton County and by Judge Alisi. So, get on to new business. Why we're here, the resolution authorizing liquidation of the regulating district Sentinel Reserve funds in the Black River area to use in payment of a judgment imposed by Fulton County, a Fulton County court decision, in order to forestall contempt proceedings for noncompliance with such judgment. Thank you, Mr. Ferrer, for that statement. And if you would like to explain it, Mr. Leslie, I would appreciate it.
Sure. As the resolution notes, it's a liquidation of $3.045 million in regulating district Sentinel Reserve funds. It'll be used in payment of a June 23rd, 2011 Fulton County Court decision, which compelled the payment of $3,045,337.65 in taxes owed to the County of Fulton and 3 school districts within that county. Judge Alisi's decision does lie against the public authority. There is a 1990 Court of Appeals case where Fulton County sued the regulating district, made it up to the Court of Appeals, and established that such judgments in the order of mandamus basically is compelling a governmental entity to do a action which they're compelled by statute to do. The order compels the entire district to pay the judgment. It does not compel one or the other regulating district area to pay the judgment. The creation of the regulating district in 1959 abolished both the Hudson River Regulating District and the Black River Regulating District, creating the Hudson River Black River Regulating District. That creation happened in our own enabling statute, Article 15, Title 21, 152137. Non-compliance with Judge Alisi's judgment does subject the Regulating District Board and/or its members to the sanctions available to the court for civil contempt. Those are fines or imprisonment. I would hazard that I do not expect imprisonment is a likely result of this. A fine, while it probably will lie against the district as a whole, in discussions with other attorneys in other agencies of government, it is not clear whether that will go to individual members of the board or to the board as a whole. As a practical matter, if there are fines imposed, I do expect that it would be against the entire board. Those fines would then be handled the way any other expense of the board gets handled. They would take precedence over any other expense that we have, just like the taxes take precedence over any other expense that we have. In order for the court to find contempt, they've got to see that there was knowledge of the existing court order. I think all 6 of you are aware of the June 23rd Fulton County Supreme Court decision that compels the payment of those taxes. The court order must be clear and unequivocal, and it is. It says the regulating district shall pay, and violation of the order must prejudice the rights of the party to the litigation. In this case, Fulton County wants their money. They've asked for it. The judge has ordered it, and you're compelled to pay it. While the board may determine that it's more appropriate to pass that fine through to the Hudson River area beneficiaries who have refused to pay the assessments due under that March 2010 apportionment and 2 subsequent assessments since then, any fine assessed by the Fulton County Court would be or would lie against the entire regulating district, which means although we might want to shelter or you may want to shelter the Black River area from payment of that fine, they'd be as liable for it as anybody else, any of the other beneficiaries. Let me speak briefly about some of the comments today and some of the comments in the press regarding whose money this is and where it comes from. The beneficiaries on the Black River side pay the expenses of the Black River area. The beneficiaries on the Hudson River side pay the expenses of the Hudson River area in its simplest form. I'm sure that our CFO could go into much greater detail and parse through that and make it more complicated, but for our purposes, it really doesn't need to be. The use of regulating district funds to satisfy this judgment does not negate the fact that the Black River pays for its expenses and the Hudson River area pays for its expenses. The accounting mechanism set up in our enabling statute to ensure that the smaller of the two regulating districts would not take on the massive debt created by the construction of the Conconville Dam in the larger of the two regulating districts when they were merged in 1959, essentially sets up this accounting mechanism where the funds will not be commingled. That does not mean that we can't use funds held in reserve for a specific purpose in one area, funded by that area, to pay for expenses of the other area as long as we account for it. And that is what we propose to do here today, is account for the funds and return them as quickly as we possibly can. The decision to liquidate these funds will have no effect on the rates or levies on the Black River area beneficiaries. There was some suggestion that there is no intent expressed in the resolution to repay these monies. And yet, on the second page of the resolution, actually, Rick's got it underlined, it's easier for me. In the second to last, be it further resolved clause, it indicates that the board authorizes the treasurer to execute a note payable for the amount of $3,045,337.65, and that said loan, in the last paragraph, said loan will be repaid forthwith upon receipt of the past due assessments for the Hudson River area that are equal to or greater than the outstanding loan balance. We can't set up a schedule, a meaningful schedule, to pay those funds back any faster than that. As soon as Albany, Rensselaer, Saratoga, Warren, and Washington County exhaust their appellate review of the court decision which makes them liable for that apportionment and subsequent assessments, we will have the funds available, and at that time we will be recommending to the board, and we expect that the board will act forthwith, to replenish the reserves that have been exhausted in the Hudson River area, replenish the reserves that are exhausted in the Black River area, and make sure that we've paid all of our debts. The resolution authorizing the liquidation does not actually effect that liquidation. The process from this point is basically we're going to bring that authorization to the settlement negotiations with Fulton County. We expect that Fulton County will agree to our payment of the judgment in full as compelled by the court, and that they will agree to the consent decree, which memorializes that agreement, and that jointly, they and us, will present that consent decree to the Fulton County Court, Judge Alisi, upon whose judgment the regulating district is compelled to make the tax payment, and that Judge Alisi will determine the sufficiency of the action and ensure that either the taxes are paid as a result of the execution of that authorization to proceed, which then causes it to go to the comptroller. Comptroller transfers the money over and we pay it. Or Judge Alisi understands, as a result of our actions and his decision, that the board has done everything it can do in order to satisfy the judgment that he has foisted upon the board, and that if we can't satisfy it, it's because of his decision. We have done such things in the past. There have been instances where the regulating district has taken this action in the past and accounted for such action as we have planned to do so here. It's been done without incident or challenge. By Resolution 86-7-2, which would have taken place in February of 1986, the regulating district established that when a deficiency existed in one area's cash flow, any amount temporarily loaned would bear interest at the same rate currently earned on the district's investments then in the comptroller's STIP account. That's exactly what we're planning to do here. The money that is currently owning interest at the STIP rate will continue to earn money at the STIP rate. It's typically been the Black River area that has needed the infusion of cash temporarily from the Hudson River area. And if I'm correct, the last such loan specifically authorized was in Resolution 87-29-6 in June of '87. And you have another example there?
Right, this is the more material example, which was later on in that same year, 1986, where there was a loan of $336,000.
That's
And that
Resolution 86-53-12.
Correct, which was December of 1986, which was the same year that the resolution to allow this to happen was passed.
So that's about the sum of it. Are there any questions that I can answer for the board?
I would just clarify just one item in terms of where the funds are derived from. The STIP of the $3,045,000, $2,769,738 are actually in the Sentinel Fund, which would be requested through the Office of the State Controller to be liquidated, and then upon the liquidation, electronically transferred to the STIP account, which in this case would be the Hudson River. The other amount, the balance, which is $275,262, would just be designated, because it's already in a STIP account, it's a prior year surplus. So that amount already resides in the STIP account and just would be reclassified as subject to disbursement for payment of these taxes. So those are the two amounts.
Any comments?
Well, thank you, Mr. Chairman. I'll make this very brief. As this board knows, I've voiced my concern about this very issue several months ago, and I've said it more than once. And, like I said, I'll try to be brief. I want everyone to know that just because I sit on the black side, I'm not taking the stand that I'm going to take because of that. I'm doing what I feel is right, regardless of which side it, affects. I would do the same. As I understand the conservation law, Title 21, I don't see where we can legally loan the money to HR. I understand that the judge, through his decision, is forcing us to do that. The way I see it, the judge is asking us to break a law because of his opinion. So if we don't give the money, we're breaking the law. And if we do give the money, we're breaking the law. So it puts all of us in a very tenuous situation. With all due respect to the judge, possibly he doesn't know about this conservation law, Title 21. I have no knowledge whether he knows of it or not. And I gave the example through a couple meetings in the past about having a corporation and then you start a subsidiary corporation. If one side is having financial troubles, you need to sever the arm so you don't take the other side down. And although we think things may go a certain way as far as winning our case and getting our tax money, the attorneys could tie it up in the courts for years. That's what I feel. Maybe it won't happen, but maybe it will happen. And if they tie it up for even a couple years, we're filling a cup that's leaking, and it's leaking quite quickly. So it was mentioned earlier by one of our guests that, we're going to, because of the court case, if we give the money, $3+ million, where do we come up with the other money? And then even if we did, or if that's an incorrect statement, then what about the taxes that are coming due soon? We're not going to be able to pay those. So as far as I'm concerned, it would be against the law, because of Title 21, for us to vote yes to loan the funds to HR. And even if it weren't illegal, I don't see from a business standpoint where you would take money from the side that is financially sound, put that money into a side that is not financially sound, and given time, we don't know, may fall off the edge of the cliff just because we haven't received the money that's due us through tax dollars. So regardless of what the judge said as far as contempt of court and all that legal stuff, I cannot, from my opinion as to what I've read and looking at the dollars and cents issues from a business standpoint, I can't see where this board can say yes to loaning the money to the Hudson side. I really can't. And I appreciate the board's patience and time and allowing me to speak, and thank you.
Thank you very much. Anyone else like to speak?
I would.
Okay.
I'm from Fulton County, as most of you know. And we can talk about court decisions and we can talk about You know, but there's a debt that we've acknowledged that we owe, and I'm also on the Chamber of Commerce in Fulton County, and I can tell you we've got a bunch of school districts that are really hurting. That's the human side of this. They've cut teachers, they've cut athletic programs, they've cut all the arts from most of those schools to a debt that, and I understand everybody's concern here, but if there's a way that we can at least partially make these school districts whole with a debt that we've acknowledged, I think we have an obligation to do just that. You know, and I appreciate the word just, I understand, and it's just something I think we should attempt to do if we can. And let next year be next year when, you know, and as long as I'm on this board, I will fight to make sure we do pay that money back. You know, that would be my goal. Thank you, Mr. Chairman.
Thank you. Anyone else like to say anything?
Mr. Chair, just briefly, I intend to vote in favor of the motion. I think that there's a clear precedent that was set, and I believe that the districts have had an interchange of money on a number of times. There is language in the resolution that will allow not only the transfer of the loan, but also the interest, so it's not an interest-free loan. And I think that we have, as a regulating district, not only a legal obligation based on the court decision, I think we have a moral obligation to pay these monies as soon as possible because of the school district and the struggle that they're having. Now, Fulton County is unique in its position, and that is not paid the school districts and then waited for the money to come from the regulating district, so that the regulating district would then pay the county. The county has not done that. So really it's the schools that are being shortchanged here with regards to the tax money that's due them. So I think that it's a moral obligation on our part to do this as quickly as possible so that we do not impede the education of the young adults that are living around the Second Naga Reservoir. So I intend to vote in favor of it, and I hope it goes through.
Mr. Chairman, I just want to say something else. I really respect my fellow board members, regardless if they're on the opposite side of me. I respect their decisions and their ability to bring those comments forth. But the way I look at it, gentlemen, too, is that our first duty, our fiduciary duty, is to act for the preservation of the Hudson River, Black River regulating district. And you might say, well, then we want to keep the Hudson River going. Well, certainly we do. But if we do it with this resolution, it could very well be the end of the Hudson River and the Black River. It may take a couple of years. And I'm not in favor of risking that. Thank you.
Now, if I might, the relatively short period of time I've been on this board has been one tough decision after another. I got on just about the time we received the federal ruling removing our source of income over in the Hudson River area, and it's been a tough decision each time. I think we've done a decent job of keeping things afloat. It hasn't been easy. Been a lot of tough decisions. And right now, we're facing another one. And I agree with two of my colleagues here that it is reserve funds that we're going to use. We are not going to touch any of the operating funds in the Black River. And that'll go on as business as usual. And it's an individual decision. It's a board decision. And that's my opinion. That I think we have a moral responsibility, human responsibility to keep things going. And I am an optimist, and I do still think that we will right the ship and things will go back to business as usual in the near future. Thank you. Anybody else? Well, then, I guess we're all familiar with the resolution?
Yes.
Okay. Any further discussion or comments, questions?
As a formality, Mr. Chair, I make a resolution authorizing the liquidation of $3,045,000 in regulating district Sentinel reserve funds for the use of payment in the judgment imposed by the June 23rd, 2011 Fulton County Court decision ordered to forestall the contempt proceedings for noncompliance with such a judgment.
Thank you. I have a motion. Do I have a second?
I'll second.
All right.
Mr. Chair, could I ask we have a roll call vote?
Yes, I was going to. Have a roll call vote, Mr. Furr.
David Bergstresser,
Yes.
Michael Astaphan,
No.
Albert Hayes,
Yes.
Philip Klein,
Yes.
Thomas Stover,
Yes.
Mark Finkel.
Yes.
5 yeses, 1 no, Mr. Chairman.
Okay. Thank you. Thank you, gentlemen, for tough decision. Any other questions or comments? I want to thank everyone for being here today. I need a resolution for the next board meeting, which September 12th.
Already made, it was already made from the line.
Oh, that's right.
Just
We're all
needed
set.
adjournment.
Motion for adjournment? What's it?
Do you want us to speak about the IG report or
Why don't we save that for September?
not? The answer is due August 19th.
Oh, is it?
We don't have to discuss it here.
The IG report. Most of the want to discuss the IG report. We need to submit an answer.
I thought we formally addressed, or I thought we already responded to the IG in letter form.
Do we?
The IG's report came out July 20th.
Mhm.
We offered an immediate response preceding that. Or we offered, they gave us a draft
Yep.
the 13th or so.
We responded to the
We
We
responded
responded
to
to
the
the
draft.
draft. They then released the report on the 20th and gave us 30 days to speak to our plan of action with regard to the items in the report. So by August 19th, we have a report due back to them.
Do we have anything different is there anything different in the initial response to the draft that would change our plan of action?
No, our plan of action articulated in this response is more detailed than was in our initial response. It has been circulated. Via email, but you've been on vacation, so. But we don't need to, I guess if you guys each can individually give me your comments, I will see if I
Just
can.
to
incorporate
interrupt, I
those.
don't see why we just can't respond via email with individual comments.
I think we can.
Is that all right? We just respond individually by email to you? The
Yes,
compilation, or is it?
I will endeavor to ensure that that is not an open meetings violation, but that is my concern. If you each respond to me,
What if we each responded to you and copied everybody else in?
well, I think if you copy everybody else in, you're in an open meetings law violation.
Oh, okay. What if we just respond to you then?
But if you respond to me without going to everybody else, if we
Individually.
need to convene another meeting to have some more global discussion,
Just, you know, my take on it was that each one of us individually comment, if we had any comments, to Rob, and then if something needed to be changed to the point where we need a special meeting, one will be called. That's the way I was interpreting it.
right.
Let's leave it at that.
Okay. And I will, if we run into any problems, I think Mike and I will speak to the Inspector General and see if we can't get more time to respond to that 30-day.
Missing the meeting.
I'll look at that Monday and get back.
Okay, thank you.
All right. That satisfy that? Right, thanks. All right, I need a motion for adjournment.
Make a motion.
A motion, do I have a second?
Second.
Motion and second, all in favor?
Aye.
Opposed? So moved. Thank you.